it is 9:01. It is a beautiful, if soggy, March day. If you are a school district that's been affected by the flooding, please know that, again, we're thinking about you. We're trying to think if there's anything we can do to be useful to you and support you. And if you are watching this live, God bless you. That means you put on your hip waders and got somewhere to watch it. I'm Karen Hasse. Steve Williams, Bobby Truey, and I make up KSP School Law, and we're going to spend this morning talking about the Student Discipline Act. We laugh because we have done this slideshow several times because it's so important to us that you understand the Student Discipline Act. And so we keep redoing it, thinking of new ways to talk to you about it, and we think we've done some new stuff with it today. But we love you all, but you still don't quite always get it. So I'm hoping that today's discussion will help us avoid some of the mistakes, issues, toe stepping that we've had involving student discipline issues with students. We have been working really hard to make these webinars good. I want to make sure they're good content as well as good ability for us to have interaction. And so this is Steve's cell phone number. You can text him questions anytime throughout the session today. We do have formal breaks built into the slides, but you can text those questions as they come to you, and we'll either answer them as we get them, or we'll save them up for the break, depending kind of on what the question is. So we crave your feedback. We're very happy to have you text us questions, and we would love to hear from you. Let's see. Oh, housekeeping wise, you should have all gotten a copy of the slides when Sherry sent out the link. We've fiddled with them slightly since then, but nothing that's too major. We also have on the website copies of all the forms, so there'll be links to all the forms you need to expel a kid, all the forms you need to long-term suspend a kid, all the forms you need to short-term suspend a kid. And we will leave those up indefinitely so that you can always go to our website on today's date and have the stuff that you need to do a student discipline matter with the confidence that you're using the right forms with the latest and greatest and most up-to-date stuff. Anything else now? Okay, we're going to start out by talking about some discipline issues that are developing because the unicameral has been very active, and well, Steve will tell you about what all they're doing.
Thank you. All right. Well, we thought we'd start off telling you a little bit about what might be changing as to what we're talking about today. We've got LB 515. I kind of call this a cleanup bill to the extent that one would exist for the Student Discipline Act. It's going to put in some timelines that don't currently exist, so we'll have to watch out for those. If students earn credits while they are out on suspension or expulsion and it's from an accredited school or program, you're going to have to accept those. Currently, you have to put in policy or when you expel somebody, let them know what your makeup policy is. That'll probably go away because now you're going to be required to let them make up homework and examinations. Currently, you get to select your own hearing officer. This bill would change that slightly. It would give the parents some input into who the hearing officer might be. And it also is going to require you to get employees to testify if parents or students want that to happen. We've got LB 165, the Too Young to Suspend bill. It's just like it sounds. You won't be allowed to suspend or expel early childhood or kindergarten students unless they cause serious bodily injury or if they're destroying property, or if a weapon is involved. We've got LB 147. This is the bill that Senator Groney has introduced. I think half of it we like, and I will say it doesn't go far enough, but my significant other is an assistant principal, and she takes the brunt of some of this abuse from students. The other half, we're not huge fans of, but the physical contact part, I like this. It kind of puts back into law something that was there, but that was taken out when the corporal punishment statutes were changed. But this allows you to use physical contact and restraint with violent students, the kids that they're beating us all up, and if they're having destructive behaviors or are destroying property. Interestingly, you can hold hands, you can hold their torso, you can hold their wrists, but you can't hold their legs, which I thought was interesting to me because that's the most damage that gets done to my significant other is when people kick her. So you can't tie them up, you can't use restraints, you can't use handcuffs. They specifically exclude that. it prohibits you from disciplining or from filing a lawsuit against a teacher as long as they've acted reasonably. And so that's the part. I actually wish they went further. In my perfect world, I call it the eye for an eye policy. Whatever the kid does to you, you should be allowed to do to them. It'll never be the law, but maybe someday. So this is a step in the right direction as far as I'm concerned. The other half, I'm not a huge fan of. I don't think any of us are. We call them snap suspensions. It essentially allows a teacher to exclude a kid out of the class, which we don't really love. We think that my fear on that part of it is it's going to allow weak teachers to simply kick kids out of class instead of learning how to do classroom discipline appropriately and have classroom management skills. So that part I'm not a huge fan of. But again, as long as they've acted reasonably, the administration can't do anything to that teacher in terms of discipline. And so we may get into a dispute as to whether a teacher has acted appropriately or not. We've got LB 390, and I should mention all of these bills are still in committee except for two, and the next one's one of them. LB 390, we've got the school resource officer bills. There's two of them. 390, Senator Pansy Brooks has made that her priority bill. She just did that yesterday or the day before. This bill is on general file. This one's going to require parents to receive notice anytime they have contact with an SRO. You're going to have a memorandum of understanding between law enforcement and the school district, which I don't have a problem with. The part I may not like, we'll have to see what happens, is NDE is going to be required to come up with kind of a form MOU. Depending on what that content is, we may or may not like it. We've drafted quite a few of these. I've drafted quite a few of these, and you can tailor them to your specific school district. You'll still be able to change them, but you can't put anything in that's inconsistent with the form from NDE. So that may or may not be a concern, again, depending on what the form turns out to be. You'll be required to enact some policies that you don't currently have. There'll be required training, 20 hours of training specific for school law enforcement, for the law enforcement officers and for school building administrators, at least one at each school building. You'll have to maintain some records, and then you have to put a complaint process in place as it relates to school resource officers. 589 is interesting. This is from Senator Chambers. And he essentially says law enforcement officers cannot be school resource officers, whether they're on duty or off duty. Okay, so let's go get somebody else. You still could. The problem is there's no corresponding change to the concealed carry statutes or weapons on school grounds statutes. Law enforcement officers basically are the only people who can carry weapons, firearms, on school grounds. And so if 5 school resource officers, they just couldn't be armed. So that's something to watch. There's a juuling bill, LB 149. Basically, that's going to criminalize the possession or use of any sort of vaping products for people who are under 21. And then finally, we've got LB 281, and this one's on general file, so it may move forward. Essentially, you have to post the toll-free child abuse hotline number on your wall somewhere in the school. So those are the changes that we have coming up. And I think Bobby is next.
Okay. Well, so one of the things that we always encourage, principals that call us with discipline questions to do, and I'm sure all of you sitting there are thinking, yeah, this is somewhere in my practice, is to think about at the front end of any sort of discipline issue, what sort of criminal and child abuse reporting obligations you may have. The problem in a lot of these cases that we see, and we see this actually playing out in some of the legislation this year, is that you are expected to understand every time there's been child abuse or some sort of violation of Nebraska criminal law. So we're going to cover these again just real briefly, but the key takeaway here is making sure that when you are kind of running through your checklist at the beginning of every discipline process, you don't leave this out. Now, we've got some bad examples that have hit the press recently. We've gotten calls in our office, frankly, from folks at newspapers that want to run stories about schools and their reporting policies. And so now is a really good time. I think never waste a good crisis. So now is a really good time to look at your child abuse and criminal reporting stuff, right? It's just because it's in the news, and now everybody that has read the World Herald understands there's a prosecution in Omaha that's happening against the principal up there. So now's again the time to make sure that you're not leaving one of these things off the table. Now that more members of the community, I think, are probably aware of these obligations. So the first thing we're going to talk about is child abuse and neglect. And the problem that we've had with some of the news coverage of this issue is it's sort of starting to read out the actual wording of the statute. So this is straight from 28.711, the statute that we have that talks about the obligations of everyone, right? We're all mandatory reporters, but also and specifically school employees and their responsibility to report child abuse and neglect. The red part of your slide, if you've got them printed in color, if not, it's italicized as well, says that anytime a school employee has reasonable cause to believe. So that is your standard, right? It's not every time we hear a report, we automatically turn around and make a call about child abuse. You've actually got to have reasonable cause to believe that either a child has been subjected to abuse or neglect, as those are defined, or you observe a child in circumstances which reasonably lead you to believe that the child could be subjected to abuse and neglect. And so there are two reporting obligations, but all of them, any reporting that you might have to do, is sort of premised by you first having reasonable cause to believe that it's happened, or that to the extent that it hasn't happened, it's reasonably likely that you've seen circumstances which will allow it to happen. So as you kind of read down the statute, you look and it tells you what you can do. So number one, you can always make a report to the child abuse hotline. I don't know that if I was a school administrator, that's the place that I'd go, just because I know they get a lot of reports depending on where you are geographically. Schools have varying levels of success calling the hotline and then getting those folks out promptly. But you can always definitely make a report to the appropriate local law enforcement officials. And so the reason that we typically say to report child abuse to law enforcement is because to the extent that it involves a student discipline issue, one child can abuse another, right? If you have a boyfriend and a girlfriend who are exchanging inappropriate pictures, if they're sexting each other, based on how widely all these definitions are written, that very well could be child abuse in addition to a crime. And so we always say call local law enforcement because that one call checks both boxes, right? Of both the child abuse reporting and then also this next section of violations of the criminal code. So not to recap all of the legislative changes from last year, but functionally, anybody that's been administering a building knows that this criminal law reporting obligation exists. And so 79-293 in our statutes talks about having to report any time that the principal believes that there has been, knows or suspects that there's been a violation of the Nebraska criminal code. The difference is that set of stuff that you had to report as of last year was tied directly to 79-267. So for those of you regular folks in the discipline statutes, you know 267 is the list of those things for which you can expel, long-term suspend, or mandatorily reassign. So if you know or suspect there's a violation of the criminal code, and it could also constitute grounds for school discipline, before the change in the statute last year, you just had to report all of that stuff. Part of the problem is that became circular because one of the grounds for discipline is a violation of a Nebraska criminal law. So you were reporting everything. Last year in the technical cleanup bill from the department, what they did is restructure this a little bit. This is where now you have to collaborate, much like you do for mandatory attendance, with your county attorney and figure out which of these crimes you're supposed to report. So you'll see the reference in 79-293 now says any of the things that are provided in subsection 79-262, which is the part that says you talk to your county attorney. So if last year you had to report it every time a kid threw a pencil at another one because that was an assault, maybe you talked to your county attorney who said, I don't want to hear about that stuff anymore. That did not used to absolve you of your reporting obligation until they changed this law. So the theory behind it is you can now work with your county attorney to report less criminal activity as long as you have agreed that that doesn't need to be reported. And so this is now the new statute in 79-262. That's where the reference to all those grounds for expulsion come back in. And it says, in collaboration with your county attorney. So on or before August 1st of each year, you have to have that discussion, similar to your mandatory attendance collaboration with the county attorney. We've heard mixed reviews on whether this has been successful and whether schools have actually gotten better guidance on what should be reported. I think several county attorneys have responded and said, let's just keep doing it how we've been doing it, which is okay. But just understand now that you do need even that clarity, right? If it's, let's not change anything, you still have to get that, or at least try to get that sort of clarity by August 1 of each year. The last thing we talk about here is that we actually have exceptions or exemptions from any sort of liability to the extent you are the reporter. Right, so all of your teachers, for example, are also reporters. Any employee of the school is a child abuse reporter. Not everybody is a criminal code reporter. The statute says principals, but both of those reporting obligations come with exceptions. So unless you're reporting child abuse and you make a maliciously false statement, you are not going to be subject to any sort of liability for making a child abuse report. Similarly, in the criminal code, unless you pick up the phone and call law enforcement after a discipline incident occurs, and you know that the report is false, and that you should have known that when you were making it, it was false, right? So if you totally fabricate it, that's going to be a problem. But if basically you believe what you called in on, and you believed making your own credibility assessments that you called in a crime that was likely or that you believe occurred, there wouldn't be any liability for a principal making a criminal code report either. Okay, now any questions you have, and then we're going to move on. I think Steve's up next. So if you have questions, make sure to text those in, but we wanted to get those preliminaries covered first.
All right.